X. My daughter is not a criminal. She is a decorated veteran, and you will address her by her rank. The woman who said that was 71 years old, small enough that the courtroom podium blocked half her face. Her name was Josephine Tamboli. She had driven 4 hours from Sudbury to Ottawa in January, in a snowstorm because her daughter could not get a lawyer, and Josephine Tamboli was not the kind of woman who sat down when her family needed her to stand. X. The man she was addressing was Tribunal Chair Malcolm Ford, 19 years on the bench of the Canadian Human Rights Tribunal, a man who had never once had his rulings appealed successfully. He looked down at Josephine the way certain powerful men look at small women of a certain age. Like she was furniture that had somehow started talking. Nobody in that hearing room expected what came next. X. Nobody except the woman sitting at the respondent's table, hands folded, back straight, jaw set the way it gets set when you have already decided the outcome, and are simply waiting for everyone else to catch up. Her name was Captain Dara Osei-Mensah, retired, and she had spent 11 years keeping other people alive in places most Canadians couldn't find on a map. Now she was fighting to keep her own home. I'm Drew. X. I cover the stories that get buried, by institutions, by paperwork, by the quiet assumption that some people are too small to fight back. This one was buried in a tribunal docket in Ottawa, under 70 pages of administrative language, until a woman with a purple folder and a mother who refused to sit down walked into a room full of officials who thought they had already won. Cassidy Heights is a suburb of Ottawa the way a parking lot is a neighborhood. X. That's not quite fair. It has streets, it has parks, it has a community center that opened in 2019 with a ribbon cutting and a photo in the local paper. What it also has is a history, not the kind people put on plaques. When Cassidy Heights was developed in the early 2000s, the marketing materials used words like diverse, vibrant, community-focused. What they meant was affordable. What they actually meant was, this is where people go when they can't afford anywhere else. X. And in Canada in 2024, can't afford anywhere else includes a lot of veterans, a lot of immigrants, a lot of black families who have been doing the math for 30 years and keep coming up short. Dara Osei-Mensah had lived in Unit 14 of the Cassidy Heights Cooperative Housing Complex for 6 years. X. She had moved in after her third deployment, after a roadside explosion in Mali had taken 2 members of her unit and left her with a traumatic brain injury that the Canadian Armed Forces Medical Board classified as moderate to severe. She had a Purple Heart, Canadian equivalent, called the Sacrifice Medal, framed above the door of her kitchen, not because she was proud of what had happened, but because her mother had framed it and Dara didn't have the heart to take it down. X. The co-op was a good fit, affordable, community-governed, no landlord to answer to, just a board of directors elected from residents. Dara served on the maintenance committee for 2 years. She organized the winter coat drive in 2022. She knew every name on her floor. Then the Cassidy Heights Cooperative Housing Corporation was acquired. That's not exactly the right word. Co-ops aren't sold the way condos are. X. What happened was this. A property management company called Hartwell Associates filed to become the co-op's administrative operator, which is a specific legal mechanism under Ontario's Cooperative Corporations Act that allows a third party to take over operations if a co-op's board is found to be in governance failure. The board had missed 2 consecutive audits. Whether this was negligence or something more deliberate was a question nobody had answered yet. X. What everyone knew was that Hartwell Associates had a pattern. In 4 other Ontario communities, they had moved in after exactly the same kind of governance failure, managed the property for 18 months, and then filed for conversion, turning co-op units into market-rate rentals. In every one of those cases, the majority of displaced residents were low-income, racialized, or both. Dara had read the Hartwell Associates annual reports. She'd requested them through the Ontario Registry. X. She read them the way she used to read intelligence briefings, slowly, twice, looking for what wasn't there. What wasn't there was any mention of resident continuity. There was no plan for existing residents. There was no transition protocol. There was a great deal of language about market optimization and asset alignment and stakeholder value. She had circled those phrases in red pen in the margin. She had written next to them a single word, who. Then the notice arrived. X. It came on a Tuesday in March. A standard-looking envelope with the Hartwell Associates logo in the corner, the kind of thing that could pass for a utility bill if you weren't paying attention. Inside was a letter advising Dara that her occupancy agreement would not be renewed at the end of the current term, 4 months from now, and that she was encouraged to begin seeking alternative housing. The letter cited Section 42B of her occupancy agreement, failure to maintain harmonious community relations. Dara read that line 3 times. Then she sat down on the kitchen floor, not because she was devastated, though she was, but because she needed to think, and she thought better close to the ground. That was a habit from her military years. When things were very bad, you got low, you stayed still, you assessed. Section 42B, failure to maintain harmonious community relations. She thought about the meetings she had attended. The 3 times she had stood up at Hartwell town halls and asked politely but clearly why the management fees had increased by 18% while building maintenance had declined. She thought about the letter she had written to the board, now the Hartwell-appointed board, requesting an independent audit. She thought about the conversation she'd had with a Hartwell property manager named Quinlan in the parking lot, where she had told him, calmly and without raising her voice, that she had a legal right to the documents she was requesting, and that if they weren't provided within 30 days, she would file a complaint with the Ontario Human Rights Tribunal. Harmonious community relations. She got up off the floor. She went to her desk. She opened the purple folder she used for housing documents. She color-coded everything, a holdover from operations planning, and she began to write. Finding a lawyer was the first obstacle, not because lawyers didn't exist, because the lawyers who existed cost money she didn't have. Her Veterans Affairs disability pension covered rent, food, medication. It did not cover $400 an hour for a housing attorney. She called Legal Aid Ontario. There was a 6-week wait for intake. She called 3 community legal clinics. 2 had closed their housing practice due to funding cuts. The 3rd called her back 5 weeks later. By then, her deadline was 9 weeks out. She called the Ottawa Community Legal Center. A paralegal named Travis took down her information and told her someone would be in touch. Nobody was in touch. She called a law school clinic at the University of Ottawa. A second-year student called her back, apologetic and kind, and explained that they couldn't take cases involving co-op housing because the legislation was too specialized. He wished her luck. He sounded like he meant it. She drove to her mother's house in Sudbury on a Friday night in April with the purple folder on the passenger seat and the legal notices in the back. Josephine Tamboli. That was Dara's mother's name from her first marriage. She'd kept it after the divorce. She said it was hers and she wasn't giving it back. Had made groundnut soup, the kind that took all day, and she listened while Dara laid out every document on the kitchen table and explained the situation in the flat, methodical way she explained things when she was trying not to feel them. Josephine listened. She didn't interrupt. She refilled the soup bowls twice. When Dara finished, Josephine sat back in her chair and looked at her daughter for a long time. Then she said, "They cited you for not being harmonious. Yes, you, who spent 11 years being harmonious in active combat zones." Dara almost smiled. "It's a legal term. It's an insult." Josephine stood up and took the bowls to the sink. "What do you need?" "I need the original occupancy agreement. The one the co-op signed before Hartwell came in." "I need to know if Section 42B was in the original, or if Hartwell inserted it." Josephine turned from the sink. Her expression didn't change, but something shifted in it. "And if they inserted it, then it's not valid. And if it's not valid, they don't have grounds." "How do you find that?" "The Ontario Cooperative Corporations Registry. Every governance document filed by a co-op has to be registered. The original articles, any amendments, every occupancy agreement template. It's public record." Josephine looked at her daughter. "You've already requested it. I've already requested it. They told me it would take 6 to 8 weeks. That's after your deadline." "Yes." Josephine dried her hands on the dish towel. She folded it neatly over the handle of the oven. She walked back to the table, sat down, and picked up the Hartwell letter. She read Section 42B, again carefully, the way teachers read things when they are deciding whether something is a mistake or a lie. "I'll come with you," she said. "To the hearing, Mama." "I'll come with you," Josephine said again. "You are my daughter, and I have nothing else to do in January. I need to stop here, because this is the moment, not the hearing, this moment." A kitchen in Sudbury on a Friday night in April. 2 women at a table under the overhead light. A purple folder full of documents and a pot of groundnut soup that took all day. Josephine Tamboli, who taught grade 4 for 31 years, who raised a daughter alone after her husband left, who watched that daughter go to war 3 times and come back each time a little quieter and a little more certain about what mattered. Josephine Tamboli looked at a letter designed to push her daughter out of her home and said, "I'll come with you," because the hearing was 6 months away. Between that kitchen and that hearing room, Dara Osei-Mensah was going to do something that no previous Hartwell tenant, no advocacy organization, no legal clinic had done. But she hadn't done it yet. She was sitting at her mother's kitchen table at 11 o'clock on a Friday night, no lawyer, 9 weeks to a deadline, a pile of documents that didn't yet tell the full story. What would you do if every door had been closed politely, with a waiting list and a phone number that no one answered? If the system that was supposed to help you was the same system that had processed every other Hartwell eviction without question, would you accept it or would you find the thread? Dara found the thread. She had submitted the registry request in April. She followed up every 2 weeks. She was polite. She used her military email signature out of habit, not to impress but because she'd never changed it. Captain D. Osei-Mensah, Ret. CD-SM. Each time, she received an automated reply confirming receipt. In week 5, she called the registry directly and spoke to a coordinator named Florence, who found her request in the queue and moved it up because, she said, "These things sometimes get buried and that's not right." Florence didn't know what was in the file. She just moved it up because someone had asked nicely and it was the right thing to do. The registry documents arrived on a Tuesday in a PDF 47 pages long. Dara sat at her kitchen table, purple folder open beside her, and read all 47 pages. She used a highlighter and a notepad. She read the original articles of incorporation from 2003. She read the first occupancy agreement template, filed the same year. She read the amendment filed in 2009, adding a dispute resolution clause. She read the amendment filed in 2019, updating the fee structure. Then she read the Hartwell Administrative Agreement, filed 18 months ago when they took over operations. Section 42B did not exist in any document prior to the Hartwell Agreement. She read it again, then again. She went back to the 2003 original. She went back to every amendment. The phrase harmonious community relations did not appear in any of them. Hartwell had drafted Section 42B themselves and inserted it into the new occupancy agreement template without a member vote. Under the Cooperative Corporations Act, a change to occupancy agreement terms required a vote of the co-op's membership. There had been no vote. There had been no notice of a vote. There was no record of any member meeting between the Hartwell takeover and the issuance of the new agreement templates. They had written the rule they were now using to remove her. They had written it themselves without authorization and then cited it as grounds for eviction. Dara sat with that for a long time. Her hands were completely still. When you have spent 11 years in situations where the wrong response costs lives, you develop a relationship with stillness. You do not move until you know what the move is. Then she opened her notepad and wrote, "No member vote, no notice, not valid." Below that, she wrote something else, 3 lines from the Ontario Human Rights Code, which she had memorized 6 weeks ago from the Human Rights Legal Support Center's guide. A co-op operator cannot terminate occupancy in retaliation for a resident's exercise of a legal right, including the right to request records or to make a complaint under the code. She had told Quinlan she would file a complaint. 9 days later, she received the termination notice. She drew a line connecting the 2 dates. She circled both ends. She had one more thing to check. The Hartwell Associates corporate registry filing, Ontario Business Registry, public database. Anyone with a computer could access it. She had looked at it months ago, briefly. Now she looked again, this time at the director disclosures. The Hartwell Associates Board of Directors had 3 members. One of them was a numbered holding company based in Mississauga. She searched the numbered company, cross-referenced it with the provincial corporate registry, found its director, found one name she recognized, Malcolm Ford. Tribunal Chair Malcolm Ford, the man assigned to hear Dara's human rights complaint, held a director position in a numbered company that held a position in Hartwell and Associates. He had a financial connection to the company that was removing her from her home. She read it 4 times. Then she stood up and walked to the window and looked out at the parking lot of her building. Her building, the one she had lived in for 6 years, the one where she knew every name on her floor, and she stood there until her breathing was completely even. Then she sat back down. She pulled out an index card. She used index cards for anything she needed to remember exactly. Another operations habit, and she wrote one question on it. She did not underline it. She didn't need to. X. She knew what it was. She put the card in the front pocket of the purple folder. The hearing was scheduled for January 15th at the Canadian Human Rights Tribunal offices on Spark Street in Ottawa. The room was smaller than Dara had expected. Wood-paneled, fluorescent lit, a raised platform at the front for the tribunal bench, tables for each party arranged to face it. There was a recording device. X. There were 6 people in the gallery. Residents from Cassidy Heights who had come because this was their case too. If Dara lost, every one of them was next. Josephine sat in the front row. She had driven through a snowstorm that started before sunrise. She had arrived 30 minutes early. She was wearing the dark green blazer she wore to funerals and important meetings, and she sat with her hands folded in her lap and her eyes on the door. Dara sat at the respondents' table alone. X. Purple folder open in front of her, index cards lined up in a row. She had prepared for 12 weeks. She had read the entire Cooperative Corporations Act. She had read every Hartwell-related filing available through public databases. She had written and rewritten her statement 11 times. She had practiced it at the kitchen table with Josephine playing opposing counsel, who was, as it turned out, a formidable opponent. Her mother had thrown objections at her for 6 consecutive evenings. X. She had interrupted her. She had told her the argument was weak. She had made her do it again. Hartwell Associates was represented by a lawyer named Sutcliffe, who came in carrying 2 bags and wearing the unhurried confidence of someone who had won this kind of case before. He did not look at Dara. He looked at his files, arranged them, looked at his phone, put the phone away. He gave the impression of a man already thinking about where he would have dinner. X. Tribunal Chair Malcolm Ford entered. He was a heavy man, late 50s, with reading glasses he wore pushed up on his forehead. He settled into the chair at the front of the room and looked out at the parties. His eyes passed over Dara without stopping. "We'll begin," he said. Sutcliffe's opening was polished, methodical, and thorough. Hartwell had assumed administrative operations in good faith. The governance failures of the previous co-op board were documented and serious. X. The new occupancy agreement had been implemented fairly and uniformly. The termination of Ms. Osei-Mensah's occupancy was consistent with the terms of that agreement and bore no relationship to any complaint or protected activity. He used the phrase lawful administrative process 7 times. X. He presented the termination letter, the new agreement, and a signed declaration from Quinlan, the property manager, stating that Dara's conduct had caused measurable disruption to community cohesion. He sat down. He still hadn't looked at her. Dara stood. She did not have a suit. She had pressed her clothes the night before at the hotel room 2 blocks from the tribunal offices where she and Josephine had split the cost. X. She wore the same dark trousers she had worn to Veterans Affairs appointments, to medical board reviews, to the memorial service for the 2 people she had not been able to keep alive in Mali. She stood straight because that was how she stood, not for effect, but because 11 years of military service had made it her default. "Chair Ford," she said, "I'd like to begin with the document at the foundation of this proceeding." She held up the 47-page registry file. X. She had tabbed the relevant sections with color-coded tags: purple for original articles, yellow for amendments, red for the Hartwell Agreement. Mr. Sutcliffe has described Section 42B as a term of my occupancy agreement. X. I would like the record to reflect that this section does not appear in the original occupancy agreement template filed with the Ontario Cooperative Corporations Registry in 2003. X. It does not appear in any amendment filed prior to Hartwell's assumption of operations. X. It was introduced for the first time in the agreement template that Hartwell prepared and distributed to residents. She set the registry file on the table and placed the tabbed pages facing the bench. Under Section 169 of the Cooperative Corporations Act, any amendment to the occupancy rules of a co-op requires a member vote. X. I have requested through the Ontario Registry all records of member meetings held between the date of Hartwell's administrative agreement and the date the new occupancy template was distributed. There are none. There was no vote. There was no notice of a vote. There was no opportunity for members to review or reject this change. She paused. Hartwell wrote Section 42B. Hartwell inserted it without member authorization, and Hartwell is now using it as the basis for this termination. X. That is not a lawful administrative process. That is a circular authority. Sutcliffe objected. Procedural issue, he said. The respondent was conflating registry procedure with occupancy law. He was smooth about it, but he was on his feet, and that meant something. Ford looked at Dara. The objection is noted. You may continue, but I will remind you that this tribunal is concerned with the human rights complaint, not co-op governance. I understand, Dara said. The governance issue establishes that the grounds for termination are not valid. The human rights issue is what I'll address next. She picked up the second tab document, a printed timeline. On it, the date she told Quinlan she would file a human rights complaint, and the date, 9 days later, that the termination notice arrived. The Human Rights Code of Ontario prohibits reprisal against a person who has asserted a right under the code. I asserted my right on October 14th. 9 days later, I received a termination notice, citing a section that did not exist before Hartwell took over. I am asking this tribunal to examine whether those two facts are related. The gallery was quiet. The 6 residents watched from the back of the room. One of them, a woman named Ada Doyen, who had lived in Cassidy Heights for 11 years, had her hands pressed together in her lap. Ford called a recess. 30 minutes. In the hallway, Josephine found Dara standing by the window at the end of the corridor. The snow outside was still coming down. The street below was white and quiet. How was that? Josephine asked. Fine, Dara said. There's more. I know. Josephine looked at her daughter. You've been carrying that folder like it weighs 40 pounds. It does, because of what's in the front pocket. Dara didn't answer. She looked at the snow. In the hallway, on his way from the chambers to the vending machine, Ford passed within 10 feet of her. He did not look at her. He bought a coffee, pressed the lid down, and walked back the way he came. Dara watched him go. She opened the purple folder. She found the index card. She read the question. She put the card back. When the hearing resumed, Dara called a witness. Sutcliffe objected. She had not submitted a witness list. Dara replied calmly that under Tribunal Rule 27-Se, a respondent in a summary proceeding may call a rebuttal witness if the need arises from the applicant's submissions. The need had arisen. She requested Quinlan Hartwell, the property manager who had signed the Declaration of Community Disruption, be required to answer questions. Ford looked at her for a moment. The gallery watched him. The clerk was recording. The witness will be heard, Ford said. Quinlan was a man in his 40s who had not expected to be there that morning. He had submitted a written declaration. He had assumed that was sufficient. He sat in the witness chair with the posture of someone who is trying to appear relaxed and failing. Dara began carefully. She always began carefully. How long had he been a property manager for Hartwell? 7 years. Had he managed any other Hartwell properties? Yes, 3 others. Were those properties also formerly cooperative housing? 2 of them, yes. Were those co-ops converted to market-rate rental after Hartwell assumed operations? He paused. Eventually, yes. She let that sit. Mr. Quinlan, in my file you submitted a declaration stating that my conduct caused measurable disruption to community cohesion. Can you give me a specific example? You were present at several resident meetings where you made critical comments about management decisions. Critical comments. Disruptive comments. I asked for the maintenance budget breakdown at the November meeting. Is that the comment you mean? You were confrontational. I used the words, I'd like to understand this better. Are those confrontational words? Quinlan's jaw shifted. The tone was confrontational. Were any other residents confrontational at that meeting? He hesitated. There was general disagreement. But only I received a termination notice. Sutcliffe objected. Argumentative. Ford sustained it. Dara moved on. Mr. Quinlan, in our conversation on October 14th in the parking lot of Cassidy Heights, I told you I intended to file a complaint with the Ontario Human Rights Tribunal. Do you recall that? I recall a conversation. Do you recall the part where I said I would file a complaint? A pause. I recall something to that effect. Thank you. I have no further questions for this witness. She waited while Quinlan left the stand. She waited while Sutcliffe conferred quietly with his associate. She waited the way she had learned to wait, still, composed, breathing evenly. Her hands were on the table, not gripping anything. Then she picked up the purple folder and she took out the last document. Chair Ford, she said, before you rule on this matter, I have one final question. Not for the witness, for the record. Ford looked up. The Ontario Business Registry is a public database. Any person can access corporate director disclosures for any registered company in this province. She held up the printed registry page. Hartwell Associates lists 3 directors. X. One is a numbered holding company registered in Mississauga. That company's directors include one Malcolm E. Ford. The room did not erupt. It went absolutely still. The kind of still that happens when something large and heavy shifts. If that is accurate, and this is a public document, filed under your signature, then you hold a financial interest, however indirect, in the company that has filed this proceeding. X. Under the Canadian Human Rights Tribunal Rules of Procedure, a member of a tribunal panel must recuse themselves from any matter in which a reasonable person would perceive a conflict of interest. She set the document on the table. I am asking, for the record, whether this conflict has been disclosed. And if not, why not? Malcolm Ford had not moved. His coffee was on the table beside him. His hands were flat on the surface. X. He was looking at the document she had set down from 12 feet away, and something was happening in his face that had nothing to do with composure. The architecture of it was shifting, slowly, the way ice shifts before it cracks. Sutcliffe was very still. His associate was typing rapidly on a laptop. One of the gallery residents, Ada Doyen, pressed her hand to her mouth. Josephine Tamboli, in the front row, sat with her eyes open and her hands folded in her lap and did not make a sound. X. Ford said, finally, "This proceeding is adjourned." He didn't slam a gavel. He just said it, pushed back from the bench, and walked through the side door. He did not look at Dara. He did not look at anyone. What followed happened through official channels, which is where these things go when the person who has spent years controlling a room suddenly cannot control it anymore. The Canadian Human Rights Commission was notified. X. A new tribunal member, Commissioner Sylvie Tremblay-Nkosi, was appointed from Montreal. She reviewed the full record, the registry documents, the missing member vote, the timeline of reprisal, the Quinlan Declaration, and the corporate directory disclosures. She reviewed every Hartwell case that had passed through the Ottawa Tribunal in the previous 4 years. Malcolm Ford had presided over 3 of them. In 2, his corporate disclosures were incomplete. X. Commissioner Tremblay-Nkosi ruled within 8 weeks. The termination notice served to Dara Osei-Mensah was void. Section 42B had been introduced without member authorization and could not be enforced. The termination further constituted a reprisal under Section 8 of the Ontario Human Rights Code. Dara was entitled to remain in her unit. Hartwell & Associates was ordered to pay costs and to submit a full governance review of all 6 properties under their management. X. The Commissioner also referred the matter of the Cassidy Heights co-op conversion to the Ministry of Government and Consumer Services for investigation, and she referred the matter of Malcolm Ford's undisclosed financial interest to the Commission's Conduct Review Board. 3 of the 6 co-op properties under Hartwell management were subsequently found to have implemented occupancy agreement changes without member votes. 2 of the 4 previous Hartwell conversions were flagged for review. X. Malcolm Ford took a voluntary leave of absence pending the conduct review. His name remained on the tribunal website for 6 weeks before it was quietly removed, and Dara Osei-Mensah went home, to Unit 14, to the parking lot she had stood in on a Tuesday in October when she decided she wasn't going to accept this, to the coat drive she organized again that December. X. To the kitchen where the sacrifice medal still hung above the door in the frame her mother had chosen, next to a photo of 2 people from her unit who had not come home from Mali. She did not hold a press conference. She did not do an interview. She sent one email to the 6 residents who had sat in the gallery, which said, "It's done. Thank you for coming." Ada Doyen printed it out and put it on the Cassidy Heights Community Board, which is where it was still hanging the last time anyone checked. X. Josephine drove back to Sudbury the same evening of the hearing, in the snow, because she had a dentist appointment the next morning that she wasn't going to miss. On the drive, she called Dara from the highway, hands-free, and asked how she was feeling. "Tired," Dara said. "That's fair, and fine. I'm fine. I know you are." Josephine was quiet for a moment, the snow against the windshield, the highway sounds. X. Your father used to say that the people who underestimate you are giving you a gift. They tell you exactly how little they're watching. Dara was quiet. "They weren't watching, baby," Josephine said, "and you were. I want to tell you something before we go. When I was growing up in Hamilton, my aunt lost her apartment. Not because she couldn't pay. X. Because her building was sold and the new management decided that her lease renewal had a clerical error in it, and they took that error and they ran. She had 3 weeks to find somewhere to go. She had 2 kids and a job with night shifts, and no one who had time to sit down and read the act with her. She found somewhere. She always found somewhere. X. But she never stopped being angry about it. The quiet anger of someone who knows exactly what was done to them and knows that the person who did it is fine and probably did it again. I wrote about Dara because Dara looked, because she went to the registry and she read the documents and she found the thing that was true. And she walked into a room where someone with 19 years of authority was waiting for her to fold, and she didn't fold. She didn't have a lawyer. X. She had a purple folder, an index card, and a mother who drove 4 hours in a snowstorm. That turned out to be enough. If this story found you, pass it on. There's someone in your circle who is in a filing cabinet right now, buried in notices and deadlines and the assumption that they can't win. Maybe they need to know that the records are public, that the registry exists, that the question is already written down somewhere, waiting for someone to ask it. X. And if you've ever walked into a room where they expected you to be smaller than you were, drop it in the comments. I read everyone.